Welcome back to the special broadcast on the Oscar Pistorius murder trial. Just days after the trial concluded, the athlete was embroiled in a public relations nightmare. Karen Morn tells us more.
Hours after Oscar Pistorius posted this tweet, his family spokesperson confirmed that the 27-year-old had been involved in an argument at an upmarket nightclub just 2 days before. These are pictures of Riva Steenkamp's friend Gina Myers at the VIP room on Saturday night. That night, Pistorius says he was confronted by businessman Jared Mortimer. The athlete claims Mortimer interrogated him aggressively about his murder trial. An argument ensued and Pistorius left. But that's not what Jared Mortimer has told us about that night. He says he was introduced to Pistorius by a friend. He also claims that the former Paralympic superstar, who is now on very strong antidepressive and anti-anxiety medication, was extremely drunk. Mortimer counts President Jacob Zuma's son Duduzane as one of his closest friends. He claims he pushed Pistorius after the athlete insulted the Zuma family. Eyewitness accounts of the incident are vastly different. One onlooker claims Pistorius swore and made vulgar hand gestures, but a waitress and one of the patrons have defended Pistorius, denying that he was confrontational. Instead, they claim Mortimer confronted the athlete, calling him a murderer. It appears at this stage that the club row will have little to no impact on Pistorius' trial. But experts believe the state may try to use evidence about Pistorius' alleged aggression during possible future sentencing procedures. Karen Morn, Johannesburg.
And then the court finally heard closing arguments early in August, the state slamming Pistorius' testimony, claiming he'd spun a web of lies.
Oscar Pistorius' estranged father, eNCA, appeared in court for the first time since proceedings began in March. Riva Steenkamp's father, Barry, was also in court for the first time after recovering from a stroke. From the outset, Harinal called for Pistorius' version to be dismissed, saying it was devoid of any truth and evidence of the athlete's refusal to take any responsibility for his actions. He's listed 13 inconsistencies, which he says the athlete concocted to back up his version. Pistorius claims he shot Steenkamp, believing she was an intruder in his toilet, ready to attack him.
The accused failed to describe the perceived imminent attack as something tangible. What was the perceived imminent attack? There's nothing tangible. It's not the door making a sound. It's not the door handle opening. At most, it's a sound. The perceived imminent attack was nothing more, on his version, really, than a sound.
He's testified that police tampered with evidence in his bedroom, but now says it would have meant the police had foreknowledge of his defense in order to sabotage it. He also spent considerable time attacking the defense's sports science expert, Dr. Wayne Derman.
Of an expert that did not take notes of his consultations with the accused, relied on his memory, would say that to the court. Lady, the court will not, with the utmost respect, accept his evidence.
The state says that Pistorius' actions on that day show that there was pre-planning. He fired 4 shots into a locked cubicle door with the intention of killing an intruder, but instead he murdered a vulnerable, unarmed woman. Pagamile Shubi, Pretoria.
Well, the following day, Pistorius' defense team had its last chance to argue his innocence. It hit back at the state, saying prosecutors ignored crucial evidence.
That the accused foresee that the deceased was in the toilet? Did he foresee that possibility? And did he reconcile himself with that? My lady, his version is consistent. He thought she was in the bedroom.
The defense team says the evidence proves that Oscar Pistorius didn't intend to kill his girlfriend. Instead, from the moment he realized he'd shot Riva Steenkamp, his lawyer maintains that Pistorius did everything he could to save her.
He was desperate to save her. That's not consistent with someone who wanted to kill his girlfriend. It's inconsistent. It's consistent with an accident, with a huge, unfortunate mistake.
The defence has presented a detailed timeline of what it maintains happened that night. Steenkamp was shot between 3:12 and 3:14 a.m. Phone records show that by 3:19 a.m. Pistorius had called the estate manager for help. But the state believes Steenkamp was shot at 3:17 a.m. If the state's version is true, it means Pistorius had approximately 2 minutes to put on his prosthesis, break down the toilet door and call for help. Proof, according to the defence, that there simply wasn't enough time for him to concoct an excuse for killing Steenkamp. Roo has reiterated that the athlete should never have been charged with murder. Instead, he argues, Pistorius should have been tried for culpable homicide.
There he is without legs, facing the door, hearing the sound, and he fired the shots. That's what this case is all about. If your finding is it was reasonable, you must acquit him.
The advocate has, however, conceded the athlete is guilty of negligently discharging a firearm at Tasha's restaurant in January 2013. After a marathon trial, Pistorius will finally know his fate on the 11th of September.
Well, that's not too many days away now. Well, Judge Thokozile Masipa and her assessors have been going through and combing through 4,000 pages of evidence. Now, as we heard from Pakhamile, 11th of September is when the world will find out eventually what the fate is of Oscar Pistorius. Well, what are the possible outcomes? It's a huge pleasure to welcome the criminal attorney expert. It's Ulrich Roo from BDK Attorneys is with us. Ulrich, good to have you on the show talking to us. Let's just understand firstly the credibility of Pistorius' testimony. The state going after that quite a lot. What did you make of it?
Well, remember, when the court evaluates his testimony, the court must find that it was credible in the sense that it was reasonably and possibly true. So, could the court put itself in Oscar's shoes and his version and find that, well, his version can be believed and that it is possible that it happened? Now, credibility is whether he contradicted himself, whether he changed his version, whether he had became emotional, whether he became aggressive, all of those things whilst he testified. And that all adds up, as we've now seen, towards his credibility. And the court will consider whether he was a credible witness, did he tell the truth, or was he being dishonest? Was there other evidence placed before the court which proved he was dishonest?
We're talking a lot about the credibility of Oscar Pistorius' testimony. What about the testimony of the individual witnesses? How does the judge and the assessors handle them? Do they simply take into account, we believe what they say, we'll keep their evidence and discard the rest? Or how does a judge handle that?
Well, the judge considers all the evidence that was placed before during the trial. So in this trial, we had a lot of expert testimony led. Now, expert testimony is different to layman's testimony, in that a layman's testimony is a person who actually experienced the incident. In other words, the neighbours. There were no eyewitnesses in this incident, so it was actually just the neighbours. Expert witnesses are there to guide the court in expert fields. In other words, the court is a lay person in that specific field, so it needs the expert to guide it. So we had the forensics and the ballistics, the sound engineers, all of those people giving testimony, and she needs to consider all of that. Now, with expert testimony, we saw that the state would lead expert witnesses and that the defense would then call their own witnesses in an attempt to disprove what the state witnesses led. So she will have to make a finding, especially on the expert witnesses, and say that, well, the state's expert witness was credible. He testified very well. He wasn't contradicted during cross-examination, and thus I believe his version and I accept his version and I discard that of the defense expert witness.
And that's why I mentioned the judgment is also going to be so long. She has to be meticulous in how she came to each of those elements in her verdict. Let's talk a little bit, Ulrich, if we could, about the various scenarios that Oscar Pistorius is facing. Ultimately, what I'm asking you is the verdict that he could very well get in the end, whether it's this putative self-defense, culpable homicide, premeditated murder, and have I missed any of them? Just take us through the scenario of the options here that Oscar could be facing as far as a verdict is concerned.
Well, he was charged with murder, and then the state attempted to prove premeditated murder against him. A competent verdict to that is one of culpable homicide. So the main difference is murder is the intentional, unlawful killing of another person, whereas culpable homicide is the negligent, unlawful killing of another person. And then we of course had what we refer to as the lesser charges, the 3 firearm related charges.
Let's talk a little bit about, I'm sorry Ulrich to interrupt you, let's talk a little bit about, for example, the culpable homicide, which to a lay person like me seems to be the least of the verdicts that Oscar Pistorius could face. If that is the situation and that is the verdict in the end, what is the sentence for something like that? Ultimately what I'm getting at is, regardless of which way this goes for the various charges, is Oscar Pistorius potentially going to see time in jail?
Well, if he's convicted on the main charge, murder, then a jail sentence will be imminent. There is a minimum sentence of 15 years applicable to murder, but the judge can deviate from that if compelling evidence is put before her. In other words, that compels her to deviate from that minimum sentence. Now, on a charge of culpable homicide, there is no minimum sentence. So the court is not prescribed as to what sentence it needs to hand down when a person is convicted of culpable homicide. Then all sorts of scenarios come into play, and that is the level of negligence, the foreseeability of his negligence. Should he have foreseen something like this happening? Now, in practice, and we've been guided by cases before where a person has been killed through the negligence of another person and there was the use of a firearm, and one would realistically be looking at a sentence of between 6 and 10 years if there were to be a conviction of culpable homicide and the use of a firearm. Obviously, the state attempted to prove that if the court finds that he was negligent, that it was grossly negligent, that he should have foreseen using his firearm and shooting it 4 times through a door without really knowing who is behind that door was grossly negligent, and that the court should award a sentence in accordance with that.
I'm so glad you're here to make sense of this. Give me your take on what the process is. We've got the verdict coming up on September 11th. What happens either way it goes for Oscar Pistorius versus the state? What's the process? Can either side appeal the verdict?
Yes, well, the verdict is being handed down on the 11th and the 12th of September. It should probably take 2 days. If he is acquitted, in other words, if the court finds that his version was reasonably and possibly true and finds that he's not guilty of the offences, then that would be the end of the road for Oscar. He would be acquitted and a free man, so to speak. The state could take that decision on appeal. Now, if he is convicted, then the matter will most likely be postponed in order for sentence to be handed down. Now, the reason why I say that is because in a serious charge, such as the charges that Oscar is facing, sentencing is a lengthy procedure. Various factors need to be considered, such as psychological reports, social workers' reports, the personal circumstances of the accused, and all that needs to be placed before the court. So she will most likely, if there is a conviction, grant the defense an opportunity to prepare themselves prior to sentencing. One other thing which also comes into play, if he is convicted, is that he would have to reapply for bail prior to his sentencing. So the court will have to consider whether the circumstances which existed during his bail application and the fact that he proved to the court that it was in the interest of justice to be released on bail are still there, and that it is still in the interest of justice to release him on bail. Obviously, if a person is facing a lengthy prison sentence, then that changes his circumstances. Does he then become a flight risk? Does it then become a risk to release him on bail should he not return to face his sentencing?
Ulrich, thank you very much indeed for coming in to talk to us. That was Ulrich Roux, a criminal attorney from BDK Attorneys. My thanks to him, and also my thanks to you for watching. Join us again on the 11th of September for live coverage of the Oscar Pistorius verdict here on eNCA. Goodbye for now.